go.
Hey, perfect. Good morning. I'm Chris Parker. This is Kristen Ishihara with the Ishihara and Parker Law Firm. And today we are talking about what happens once you've done your work. I came in, I saw the attorney, I got my estate plan done. I even did the follow-up. It was a trust and I funded it. I got this big fancy package of folders and documents. What do I do with it? Is it a doorstop? Is it a put on the file? What do we do when we're done?
Good job.
Yeah.
Can we say good job first? Good job for getting it done.
Yeah.
You're one of 50% of people that actually get their estate plan done. So congratulate yourself for that. Take your spouse out to dinner. Enjoy being an adult and getting your stuff in order. But first, we want to talk about, one, who do you need to share that plan with? So who needs to know that you got that done? Let's say you're married, so you did something with your spouse. Obviously, they participated, so they know you got it done. But then you probably have some kids, and you probably have some agents. Now, we want to be clear. You don't have to share this plan with anybody. This is just our general advice, and it may be different than your specific situation. So if I have 3 kids and I've not left anything to one, obviously we're not going to share the estate plan with them. We don't need to do that necessarily. Yep. But the people that for sure need to know that you have this in place are going to be the people you listed as agents. So if you've selected somebody as an executor, maybe that's a kid or a brother or a friend. Ideally, honestly, you've talked to them about it ahead of time and made sure they understand what their duties are and that they're willing to serve. But they need to know that you've completed the plan and have that in place.
Yep, absolutely. Everyone's different, and if you have, like you said, that there's family dynamics that make things difficult. Well, maybe you don't share it with the folks that'll be difficult for. But I've had many times where people have come in and said, "Hey, I've got 2 kids, and while I'm splitting most things 50-50, I want my daughter to have this property." And we've talked about that, and some comes down to personality. But I've often encouraged folks like, "Well, hey, if you have mature children and they're just wanting to do whatever you want, I don't think there's a problem necessarily with sharing that plan." People who've shared their plans with the right family dynamics have had smooth sailings. They set expectations, and those things happen and they pass away. When I'm thinking about those, the actual physical copy, where is it gonna rest at night? Is it going in a safe deposit box? Are we gonna put this in a safe? I mean, we have it, we're sharing, we're telling them about it, and they're gonna go find it where? How do we store these things? How do we share these things? If I share it with them, how do they get to it? I mean, do we have comfort levels here?
Sure. So when we're talking about sharing a copy, that could be a paper copy or a digital copy. And that, if you are comfortable sharing, that could be done to kids, to other beneficiaries, and to agents. So if you're comfortable giving it to them, that's fine. I would say the downsides of that are usually your plan is going to be revocable or changeable by you. So if you've given a copy to someone and you ever change it, you do need to make sure and go back and update with them that there have been changes made. Yeah. So sometimes that's an argument to not give copies to a lot of people. But so we've handled copies. You've determined who you want to give copies to. Now, where do we store the actual originals? The original needs to be in a safe spot. And then the agents that need it need to know how to access it and have access to it. Yeah. So again, if I've listed my child as my executor, they need to know that I have originals, where I'm keeping them, and then they need to be able to access them. So if I'm going to store my originals at home, what are some places I might keep that at home? Yeah,
I mean, I've seen it as simple as putting in that file cabinet that nobody messes in, right? The file cabinet, important documents, it goes right there. Plenty of people here in East Texas put them in their gun safes. We have that happen over and over again. Usually a adult child will knock on my door and say, "Hey, Chris, what's the combination to Dad's gun safe?" And we have no idea. So let's not get your stuff drilled. Make sure people can get into it. So I see the file cabinets, I see the gun safes, I see the safe deposit boxes. Those are all kind of the standard, the gold standard, if you will. But each has their own risks. I mean, if your house burns down and we lose those documents, it's going to be an issue. I warn everyone all the time. We keep bringing up originals because eventually the originals will be needed. The original will be needed for court. The original power of attorneys very often at some point will be needed. So it's got to be someplace safe. It's got to be someplace accessible, but we will need those originals someday.
Sure, and if you're going to use a safe deposit box at the bank, we always want to point out that that's a perfectly fine idea. You need to make sure that someone knows that it exists, because a lot of times we don't share that information. And then 2, that the person that needs access to it is actually on the signature card of the box. Once you pass away, if they're your power of attorney or if they just have a physical key, they cannot access the box. So they need to go into the bank with you, sign the signature card, and have the same access to the box that you do if that's the plan for where you're going to hold your originals.
Yep.
I would also just point out that safeguarding originals gets more important if you have any sort of conflict in the family, because the court will assume if you cannot, or if your executor cannot present the original will, which is the handwritten wet signature, the one that you signed, if the executor cannot present that to the court will assume that you intended to revoke it by destroying it, and that will increase their burden on proving that that is actually your will. So if for any reason there will be a conflict, like you cut out a child or you left something to somebody, make sure that that original is genuinely safeguarded, because if that original something happens to it, your wishes may not be carried out in the same way that you want them to be. So very important if you are having any sort of conflict in the family or leaving things in a way that might be controversial. 100% up to you on how you do that, but to make sure it gets done correctly, you definitely want to have a validly done will and then safeguard that original with the people that need access to it being the only people that have access to it.
Yep.
We forget sometimes that once you die, pretty much everybody has access to your house. Whether legally or illegally,
right.
You probably gave them the garage code. They probably had a key. So while you were there and safeguarding it, they wouldn't have come in and gotten it. But now that you've died, it might be the first place that they go.
That's right.
So
that's right. And of course, as we come to storage and sharing, if you have a good relationship with your financial advisor, they need to have a copy of your financial power of attorney, right? We need to share these things. You have stored it at home. You're sharing with the right people. People need to know their roles, and people need to know who has that role. If you've got an Edward Jones or Wells Fargo, whoever you bank with, Texas Bank and Trust, you want to make sure that they have a copy of those powers of attorney so they know who they talk to. I mean, you have to tell the people who are agents, like, hey, friend, neighbor's child, I'm counting on you to be that person. But then you need to make sure those third parties that control or could control a lot of your life know who to trust as well, right? I mean, I love to have those power of attorneys shared with the institutions who may have to rely upon them. And if you give it to them 20 years in advance and they meet your agent over the next 20 years, they're going to have confidence when that agent starts acting on your behalf. You show up with those wet ink power of attorneys or some strange person has showed up, you want those institutions to be on guard against those kind of situations. And I think the best way is to arm them with it. Keep the original safe, make sure the right people have copies of what they need to have, and people know their roles.
Sure. I would say that's number 3, is making a comprehensive plan with what you've put into place. So, your work doesn't stop necessarily after you've signed the documents. Your attorney should be helping you make a list of homework. And if that's a trust, that's funding the trust. If you have a will, that's making sure that your beneficiaries match and work with your will. So if you've left specific distributions of cash, you need to make sure that some cash comes into your estate when you die. If you have all adult children and they can be listed as beneficiaries, you need to make sure that all your beneficiaries are up to date. And like Chris is mentioning, all your powers of attorney should be distributed to financial institutions, ideally even taking that agent with you to your next annual meeting with your financial advisor or straight into the bank to meet your local banker. Those are things that you should be doing to make sure that the estate plan is carried out efficiently, but making sure your beneficiaries are done correctly so that that's part of your plan, and then making sure that your agents are introduced to the people and properly documented with anybody that they may need to work with if you're ever incapacitated and they need to say, hey, this is what we're going to do with the RMD this year, or this is what we're going to do with these things. So making sure that all those steps are in place.
All right, so Kristen, I got my documents in. I came, I saw you, I got it all lined up. I then took it home, set up a place where I'm going to store it, either at the house or at the bank or wherever I'm going to keep it. I shared that important information with the people who have leadership roles in my estate planning. And then I took it to the folks who needed it, financial institutions, banks, maybe my doctor's office. I shared it with the important people. And so then I am done, right? I've got it all done. I did my adulting. I saw you guys. I spent some hours lining this all up. And I'm going to sit back and I can then die in peace because I know I've taken care of business. Except, as we know, time marches on and things change, right? What would be Or, I mean, why would I need to revisit what I just did?
Sure. I mean, maybe you can just sit back and die in peace 20 years later, but we definitely want to pull that plan out at least annually. That's our advice. Look at it annually. That doesn't mean you need to go see your lawyer, but review it annually to make sure that no agents have passed, become sick themselves, had life events, no beneficiaries have maybe gone through a divorce or become disabled or nothing's changed. So we want you to review it at least once a year. And then every time you have a life-changing event or someone in your immediate family does, we also want to pull out that plan and look at it. So if a child gets divorced, do we need to think about that differently? If you have a child that dies, do we need to think about that differently? If your spouse dies, you need to think about that differently. If your spouse has a diagnosis of dementia, we need to think about that differently. So when we say life-changing event, we usually mean death or illness, also disability, and divorce, probably usually for a kid. Although, of course, if you get divorced, you should definitely update your estate plan as well.
Yeah, I mean, if you have your spouse, your loved one, as your beneficiary and as your power of attorney, and heaven forbid they develop dementia, well, they're not going to be a good agent for you. That's just a change that has to be done. It's not that we don't love them; they just can't serve in that role for you any more reliably. So we're going to update our powers of attorney, and then we're going to look at that will. Well, there's a lot of stages of dementia. And these things happen. Some are progressive, some are fast, some are slow. There's some folks with these kind of diagnoses that are perfectly capable to inherit and take care of business. Other times we might say, hey, they probably need some help. So let's have that adult child step into the role as executor or trustee. These things change. And as a person's condition changes, as their mental health, as their physical, as their, biological children born, pass away, whatever, you need to update these things. The planning we do does cover a lot of aspects. It does. We cover a lot of scenarios. But if we know for sure that a path has been taken, then we would change our planning to match it.
Yeah, absolutely. And one other that I wouldn't add on the list because we've done other videos on it, but just having kind of your after death list or guide, having a list of what assets you have, so that, that's not necessarily something you need to provide ahead of time to anybody, but just if you passed away unexpectedly, they could walk in and know I have life insurance here, I have retirement here, I have these things here. So it wouldn't be searching for months to figure those things out. But that's always a good advice to have. And in the event of incapacity or death, very important for your agents. So number one, make sure that we've stored it in a safe spot and the person that needs it has access to it. Number two, share copies as you determine you should. Number three, make sure that your plan is comprehensive and that all parts of your plan are shared with other financial advisors, CPAs, and anyone important in your life that needs to help support you. And number four, update it with life events or annually and make sure that no changes are needed.
Yeah.
Cover everything?
Yeah. We love it when people show up, we don't love it, and tell us, hey, here's all the work you completed. It all makes sense. It's a much more difficult conversation when someone comes in and say, hey, heaven forbid we lost our loved one. We need you to give us the will now. Or we need the documents. And I think, Mom had those. So, yeah. Moving can be dangerous. Transitioning houses, moving to assisted or independent living. That's where we've noticed transitions can be dangerous. So keep an eye out for those.
Yeah, and you're always in charge. So if you want to make changes, make changes. If you want to, leave something to grandkids, leave something to grandkids. All of that is your stuff. So once you've put that estate plan in place, that doesn't mean you can't change it. You can change it anytime you want. It remains your stuff, so you change it as often as you feel necessary. You're not locked in. You haven't given anything away. If you've given a house to a kid, you can still sell the house and spend all the money. So everything is always up to you, and we just want to make sure that at your death, everything goes the way you want it to. So anyway, thanks for joining us, and we'll see you next time.
Thank you.